afternoon. You keep it seated. Good afternoon, Your Honor.
Good afternoon, Judge.
We're here this afternoon in State versus Donna Adelson, 2023 CF 3226. Two motions we're here for this afternoon would be the defense's motion to compel and also the defense's motion to extend previously ordered deadlines for witnesses, exhibits, and pretrial motions in completing discovery. Part of the reason I believe we need to have a hearing on these matters as well, and I'll let you make your argument in just a moment, Mr. Zellman. Have you discussed with your client specifically as it relates to the raw data that you are seeking, specifically for Charles Adelson and herself, that this has the potential to reopening the door of the conflict?
Your Honor, I don't think that it would. It's in the same category as the emails that Your Honor authorized us to obtain in April, the raw, unredacted, unfiltered emails from our client's own account.
While they are certainly discoverable and while you have an interest in using them to prepare for, the question remains. Have you discussed with your client the possibility of this reopening the door to any conflicts?
No, we have not, because I don't think that it would reopen the door.
Very well. You may make your argument.
So, Your Honor, you may recall a number of times we've been before the court, and the defense, and as laid out in the motion to compel, we have been asking for the raw, unredacted downloads, the emails, and we were repeatedly told that that had been provided to us. When we were able to retain an independent forensic data expert and provided them with the materials that we had been provided, we were informed that those are not the raw forensic extractions. And I was asked to obtain the raw forensic extractions. And in the motion to compel, I actually cut and paste the expert's explanation. I'm not going to try to paraphrase it. It's an explanation that he provided as to why it is his recommendation that we obtain the raw forensic extractions. That's what I did. I've requested that. It's taken, we're now at a month since I made that further request, and I believe that we're entitled to that. I think the rule provides that, and our intent, in part, is to verify the cell brights that the state has prepared. The only way to do that, according to our expert, is to obtain the raw extractions from the state. And that's why we're asking for that, Your Honor.
Ms. Kappelman, you may respond.
No objection, Your Honor. I would just ask that whatever reports are generated by their expert as a result of that data being re-cell-brighted be provided to my office in a timely manner, because I'm advised, based on the version of the program and the type of program they use to produce a report to verify our report, there could be some small differences involved. So I would like to not be surprised with that at trial.
Well, as to that, I will grant the defense's motion to compel. As to the issue of the conflict, specifically, Mr. Zellman, in part, when we had the first case management, I had counsel verify that they had no conflict as far as giving conflict-free representation to Mrs. Adelson. Should anything change with your review of these cell brights that may include communications from prior counsel or deal with matters that pertain to information that was provided by Charles Adelson, At that point, we are going to have to revisit the issue. Does everyone understand those?
Yes, sir. May I approach with a proposed order?
You may.
This is just the same one that I had sent.
I don't know the name. I don't have it. I got it.
Dave, if you're copied on the emails, Corbett is ready to do the upload evidence.
Okay.
Thank you.
And Your Honor, just to advise the court, Mr. Corbett and the defense expert have been communicating over the last 18 hours or so that once that order was signed, Sergeant Corbett was going to upload that to a portal that they've already tested this morning, so that our expert can download it. That'll be the fastest way for them to do that. He said as soon as, Sergeant Corbett indicated that as soon as he was given instructions to start the process, he would do so.
Right, as to the second motion, the extending of all deadlines for the defense. In particular, we've already had 2 extensions that have been provided by the court, first from the April 30th deadline, second from the May deadline. Does the defense have any motions that are unrelated to the new discovery?
No, Your Honor.
All right. As to the motions that you believe you still need to file that are in some way related to this discovery, what is preventing these motions from being filed and you seeking leave to amend as necessary?
Your Honor, due to scheduling, we were only able to depose Mr. Newland and Sergeant Corbett Wednesday, Thursday. We are deposing Special Agent Pat Sanford, I believe, on this coming Tuesday. Before filing those motions, I think it's appropriate to make sure that there's a good faith basis to do so. And having those depositions, that testimony, in my opinion, is necessary before we can do that.
Right? And I believe there are some other depositions that are scheduled for July, or I believe next week as well.
Yes, sir, we have them on Monday as well, and maybe Tuesday and Thursday.
Part of the reason that we have, whether it be discovery or any sort of deadline cutoffs in any case, is not simply arbitrary of the judge just saying, get it done by a certain date. It is so we can proceed orderly to trial. I believe your proposed dates were to within 4 weeks of when you believe the state has fulfilled its obligation. That's when you would want to file your motions.
Well, Your Honor, given that we filed these on June 27th, we're obviously 2 weeks past that.
Oh, yes, we are.
And it's certainly not our intent to do anything to delay the commencement of the trial as scheduled.
The proposed date of when this would occur is not specific. It's not certain. It's pretty much a moving piece of jello. Is there anything that you can do to convince me that it's otherwise going to be a specific date in what you're asking to do with filing these motions several weeks after you believe the state has complied?
Unfortunately, it has been a moving target because we have not received all of the discovery from the state. During the depositions, during yesterday's deposition, we learned that he had conducted call frequency analysis between Donna Adelson and Charlie Adelson for a longer period of time than that had been previously disclosed. He is going to send us that if he had completed a report. He's also sending us the PDFs of the actual call frequency analysis that is contained in the demonstrative, because those are just excerpts of the call frequency analysis. So he's going to be sending us the completed call frequency analysis. So I say that to demonstrate that it is difficult for the defense to file any appropriate motions or to provide appropriate responsive either demonstratives or exhibits when we still have not received everything from the state.
At the same time, to file, and how many motions are we talking about at this point?
Potentially 3, Your Honor.
As to these 3 motions, would any of them affect the ability to actually move forward with the trial on August 19th?
No, I don't believe so. None of them are dispositive.
Very well. Do you have any further argument in support of your motion?
No, Your Honor.
Ms. Kappelman?
No objection, Your Honor. We've just asked that we be given the same grace. I'm aware of at least 1 or 2 more things that the state intends to do that could, need to be done past the deadline. So all indications are that both sides are working diligently to get this done. I understand your comment about the Jell-O, and I've got a couple orders myself of Jell-O that I'm wrangling, so I'm trying to minimize it, but things do come up past the deadline, so we're going to have to work
Ms.
through those
Kappelman
things.
specifically asked these emails, which has contributed to this. What is it else that you believe is going to come up on the state's behalf?
The emails?
I said, other than the emails,
Oh,
what do you
do
think
I
is going
think's
to come
gonna
up on the
up?
state's
There's a
behalf?
defense witness that's been listed that the state has discussed trying to depose and may try to get that done before the deadline. There's a handwriting expert that the defense is aware of, that a handwriting expert exists, but they haven't been given the name or the report yet. I don't have the report yet, so that's something that's pending that would be in violation of Your Honor's order. So there are a couple outstanding issues that I'm aware of. I was not aware of the issue that the defense just brought up regarding Corbett having done a report, but he does do work to generate the slides that were prepared and discovered by the discovery deadline. When asked about how did you come to those conclusions in deposition, he's going to say, I looked at the data. Well, they want to see that data. Okay, we don't object to that, but I don't think that's the same thing as a discovery violation.
The final pretrial hearing is August 8th. As to the date of when all motions need to be filed, so we can have a meaningful hearing on August 8th and proceed to an orderly trial on the merits. These motions are going to need to be filed by July 21st. Any motion that is not filed by either the state or the defense by that date, the issues are subject to being deemed as waived. If you need to seek leave to amend as to the specific motions that will be filed on this date, you may certainly do so. However, again, this is not just arbitrary date making to throw something out. If we are going to in fact have a trial on the merits that will be orderly, both parties needed to see what you intend to raise as pretrial legal issues that the court needs to rule upon. There's not going to be a trial by surprise either for the state or for the defense. Am I making myself clear?
Yes, Your Honor.
Yes, Your Honor.
Will you state those dates one more time? Motions to be filed by July 21st and final motion hearings on August 8th, is that correct?
The final pretrial hearing is on August 8th. This time has already been set apart by a previous order. As to the motions in limine that have been filed, I believe the defense has renewed its motion concerning the Latin Kings. Is that correct?
Yes, Your Honor.
Has the state filed any motion in limine by the previous deadline?
We renewed motions that were filed previously. There's nothing new.
Well, as previously ordered, copies of all of these motions, when they are filed, they need to be served upon the court. Please do so if you've not already done that regarding what has already been filed. believe the next date that we will have, unless there are other issues that need to be addressed, will be August 8th. Does either party have anything it needs to raise?
Nothing from the state, Your Honor.
Can I have a moment, Your Honor?
Go ahead.
Nothing at this time, Your Honor.
Well, we are in recess for this afternoon.
Thank you, Your Honor.
You can, yeah, go ahead. What's that? It's good to file as is.